Well, and certainly because like Massachusetts and Connecticut aren't going to say like, okay, well, New Hampshire says this, so then we're just going to give up on your residency when we have like a true income tax, at 9 to 6 to 12% or whatever their individual rates are. So yeah, that's interesting. And we don't deal, with a lot of individual domicile issues just from our area of practice, just because it's really interesting to hear, something new, especially again from like states that, you generally don't hear as being like the bad guys, right?
Yeah.
Certainly where you're low, being in Maine, you get that, but
yeah. And, I think New Hampshire, in our experience, and I'll say something nice about the Department of Revenue Administration in like our
we're not beating on them. No,
they are quite reasonable, and they're good to work with, and they will like have conversations with you. And for whatever reason, this case, they have just sort of dug in, and it's a little bit surprising because this is a tax that's going away in like a year. So,
well, and is it more out of, and I know you can't talk about it, but like when you think about like interest and dividends, like the materiality, like how much money are they actually going after, particularly if they're kind of focusing on this 1 year? And, is it more of like a principle argue, like out of principle, this is wrong to take, to litigate versus, fighting, and this is kind of an overarching conversation too, is like, when do you actually get to, or should you take something to court and bear those costs for, how much tax is at issue? But one, it's kind of regardless, admirable for your clients to kind of push the issue because that's how you get answers, right? Audit settlements don't give answers to the general populace.
Right. And I think we lucked out with the client. I think he perceives how unfair this entire audit is. And, he has the willingness to litigate. So it's a good client relationship. Yeah.
Well, some of the more recent cases that I've read, it's kind of like, it's like $100,000 on tax for like a large corporation, right? Where it's like, that's really not that big of a deal. But, to establish a true answer, kind of like Wayfair, right? It's probably not a big deal to just go ahead and collect. Big deal. You can agree on something, but at least you have that public answer that in theory, people are going to be held to, or states or businesses or whatnot.
Yeah. No, I think you're right. And that's an issue that, practicing in a relatively small state, we run into that issue quite a bit, where the tax issue itself might be very interesting and very meaty, but the amount at issue is just, it's not that much. Like, you're not going to have your biggest tax assessment in Maine.
I mean, it's so, to Meredith's point, I agree. It's so nice to see taxpayers willing to go after it, right? I mean, Halstead Beat is another kind of, company that comes to mind that is pushing back, right, publicly. Right. And it's I think fantastic that they are. So whenever I hear about taxpayers doing that, even when the materiality might not be there, right, from a cost benefit perspective, a cost of litigation, right, risk of loss perspective, they're doing it anyway, and that's amazing.
Right. And to maybe like switch topics a little bit again on that cost issue, in our litigation. So the way that things work, and I think this works the same way in a lot of states, is that by the time you reach either the Board of Tax Appeals or Superior Court, you're dealing with the Attorney General's office, and they have a few attorneys over there who focus primarily on tax issues. And one of the, recent battles that we've had, which is not even a tax issue, is about confidential information. So in many of our recent corporate income tax cases, primarily, the attorney general or like the assistant AGs have been really pushing for disclosure of confidential taxpayer information, like tax returns, and then just like confidential information of the taxpayer, like details of contracts. And I think Maine, like a lot of other states, has a statute on the books that protects taxpayer confidential information, like tax returns, things like that. But there's this carve out that allows the production, like the language is like production in court of so much and no more of the information that is pertinent. And the assistant AGs have been taking the position that this language that says, the production in court is permitted. And they've taken that to mean the production to the public. So not only to like the court, but to the court in a publicly accessible manner, which is, from my perspective, not at all what the statute says. And this kind of originated, I don't know if you guys remember, there was a big Apple case out of Maine a couple of years ago. It was a sales tax case about what the correct purchase price of a phone when it was sold with a long-term contract. And a side issue in that case was the fact that the parties had agreed to a confidentiality order, which is actually a form order that the business court here has. And the assistant AGs really wanted disclosure of contract pricing, which is, obviously like very sensitive business information and has nothing to do with the case at all. It doesn't, like, the tax price has nothing to do with like the actual number at issue, or the sales price has nothing to do with the actual contractual payment amount. It either is part of the sale price or it isn't. And the law court, which is what we call our Supreme Judicial Court. So the law court essentially ruled like, yeah, this confidentiality order is pretty broad, but it's not an abuse of discretion for the trial court to agree to seal that information. And so since that case came out, we, like, in every single litigation, we've seen the AG is like trying to disclose like contract pricing. They're trying to disclose like tax returns. They're trying to disclose customer names, like things that are really tangential to the issues involved. But we have kind of a mini litigation that's to the side of the main show. Yeah. And luckily, at least so far, trial courts seem pretty skeptical of the AG's arguments, and they've been ruling in our favor, and they've been protecting this information. So that's the good news, is that it's not getting out there. But the bad news is that, again, it's adding to the costs of a case that might not have a ton of tax dollars involved to begin with.
Can you share any theories as to why you think they're doing this? Is it just a litigation strategy, or do you think there's something else driving?
So we've talked to them about it. At least we've talked to one person within the office, and his position is that the public should have access to the courts, and the public should have access to what's going on in the courts. And I won't speculate beyond that.
Answer the question.
What's that?
Doesn't seem to answer the question, but I mean, not my question, the question.
Yeah. I mean, I can only talk about, what the effect is on our clients, which is like, you have to have sort of a tolerance for the additional costs of battling information.
How long have you seen that they're kind of picking on that? Like is this like the last 5 years, the last like 6 months, or is this just
Yeah, I would say in the last like 2 to 3 years, there's really been an uptick of battles over what to disclose and what not to disclose.
It's interesting.
Yeah, and I mean it goes towards, you know, a lot of it goes towards like voluntary compliance issues. You know, you want your clients to feel comfortable turning over documents in an audit that will support their position, even if those documents include confidential information, and not have those documents included in public filing.
Yeah. Yeah, I think that's a really interesting issue that I don't know that we've really heard many people bring up kind of in conversation. So we appreciate that insight and something new.
That's
and
great.
So on that spirit of newness, we're going to skip Wayfair because everyone talks about Wayfair. But what we really want to make sure everyone knows,
We don't talk about Wayfair.
We don't like Wayfair. Well, we love Wayfair, but we hate Wayfair.
That is
that's an inside joke.
An inside joke in a podcast.
Well, but I'm going to let them in on the inside joke.
Nice.
So to our listeners, we're not on the inside joke, and that's probably all of them. Olga and I co-presented at the ABA IPT conference this past March, and our panel was titled "We Don't Talk About Wayfair" because we're typically Wayfaired out, but there's still things to talk about. So anyway, an inside joke within an inside joke.
But we're really not going to talk
I'm just
about
a CPA, so I don't understand. So I don't go to ABA. So, but you were honored this year with the Lancaster Pro Bono Attorney of the Year Award for pro bono hours. Would you just like to share a little bit of that as we say congratulations? And, you know, that's all, like, just congratulations.
Thank you. Yeah, so almost all, if not all of those hours were dedicated to a pro bono property tax case for an organization called Peace Ridge Sanctuary, which is located in Midcoast, Maine. And I get really, really excited talking about this case because I don't think we get a lot of opportunities as tax lawyers to take on these like really big pro bono litigation opportunities. So thank you for asking about it. I was excited to receive the award, but I was more excited that we won the case. So I will tell you about the case and the organization and what happened. So Peace Ridge, like I said, it's a nonprofit animal shelter that houses and cares for like all kinds of farm animals. And when I say farm animals, I mean like every single kind. There are horses and pigs and donkeys and cows and birds and goats, like very, very cute goats. And also they have dogs. They have rescue dogs. And so that's what they do. They're one of the largest animal shelters in the state, and I think actually in the country, because of this property that was the subject of the litigation. And so Maine as a state, we have an animal welfare program where if there are animals that are being mistreated or neglected, there are humane agents that have authority to seize the animals. And then there's like a civil or even a criminal, potentially, court proceeding. And so this animal welfare program essentially relies on Peace Ridge to take in the animals that are seized and house them, provide them medical care, provide them some rehab, food, shelter, everything that the animals need. And when I'm talking about they rely on Peace Ridge, it's not like sometimes it's, we'll see like a horse kind of standing out that might be like malnourished, for example. But in a lot of cases, it'll be like a flock of 40 sheep. So it's big, big numbers. And the state really couldn't do this work without the support of Peace Ridge. And in a lot of the cases, the animals are ultimately relinquished by their owners, as part of the court proceeding, and Peace Ridge will house them for the rest of their natural lives. So this all started in late 2015. Peace Ridge received some donations that allowed them to buy this really, really huge 800-acre property in the town of Brooks. Before that, they were on a pretty small property in a different town. And so this property allowed them to take in tons of animals. Like at this point, they have hundreds and hundreds of animals on this property. But they had a dual mission. So part of the mission was animal sheltering. And then the other part of the mission was that they really wanted to conserve a good chunk of this property for wildlife habitat. There's a lot of cool, diverse habitats on the property. There's a wetland. If you like bird watching, it's kind of a paradise. Lots of migratory birds there. And so the legal issue was, is Peace Ridge entitled to a property tax exemption for this 800-acre property? And Maine law allows the exemption for benevolent and charitable organizations that own and use or occupy the property for their own purposes. This seems like a no-brainer. I think, they are an animal shelter. They're not for profit. They're using their land to house all of these animals. They also do a lot of programming. They'll open the property up to the public every once in a while. So they're doing a lot. And it seems like the answer is obvious. But
Olga, can I interrupt you? Who's the villain in this
I'm about to tell you about the villain. So the villain is it's not the villain, but the elephant.
No, I know. I'm being dramatic because I'm sucked in. I'm emotionally invested in the story.
Just cute animals, right?
So you've set this up quite well.
You're not talking about Trump's golf course in New York that, gets its own easement.
Yeah.
Anyway.
Yeah. As far as I know, there are no bodies on this land. So they applied for the exemption their first year, 2016. The town just was dead set against it. Right from the start, the town just kept denying the exemption. And so when Peace Ridge's executive director went to a select board meeting to kind of talk about their work and all the good that they're doing, the selectmen responded by taking a poll on her age. They all went down the line and they all tried to guess how old she was. And this came out in testimony from some of the selectmen. So this is an undisputed fact in this case. So that's kind of how it started, with really egregious behavior by these folks. And there were comments made during this meeting about how they needed to assimilate, that they needed to cut down all the trees on their property to pay their property taxes, which is pretty antithetical to an organization that's trying to conserve wildlife habitat. And there's just all kinds of side discussion and nothing about what Maine law actually required for the exemption. That really never came up in any of these meetings. And I think it's small town issues. Feelings get hurt. People sort of get entrenched in their positions, and so this went to trial. There was really nothing to do but go to trial, and the trial got canceled a few times. We were supposed to go to trial, I think, March 17th, 2020.
Good timing.
So we got an email from the court at 10 p.m. the Friday before saying that all the courts were closed. Then they got rescheduled for late summer and canceled again because they couldn't find enough marshals to protect the judge. So
to protect the judge from what?
Anything at all.
COVID?
I think you need to have marshals just to keep the order in a court. Yeah. And so then we finally had the trial. It was in May 2021, and it was mostly on Zoom. So that solved all of the issue. Except that I say mostly on Zoom because one morning of the trial, all of us carpooled and caravanned over to Peace Ridge for a site visit. And I will say that this was 100% at the suggestion of the town. I think they just wanted to go look at what was going on at Peace Ridge. So it was like all of us on the Peace Ridge team, a bunch of select people, the assessing agent for the town, their lawyer, the judge, and his marshal. So they got a marshal for the site visit. And we just like spent this morning walking around the property, looking at like really, really cute animals. It's the way I describe this property is it's basically like a petting zoo, but the animals are like friendly to humans because they've learned that humans are good because they receive such good care at this place. And there was this one moment where there was a three-legged goat, and she hopped over to one of the selectmen and like nuzzled in like she was a puppy. And the selectman like completely fell in love with her and was just on the ground petting her little head for the next 20 minutes. And at that point, the judge turns to me and he said, "Counselor, did you plan this?" So, like obviously we didn't, but I feel like maybe that was the moment where if there was any doubt, that resolved.
It sounds like somebody had a chat with that goat.
Right?
Yeah, I don't know. And so from just like a factual perspective, I think things were like, it was very clear. Like there were like dogs being walked on trails in the woods. They were clearly using the property for this animal shelter purpose. But there actually were legal issues involved that might be of interest. So one issue was, can Peace Ridge even qualify for an exemption? So like in the normal course, you have to submit an exemption application. If you don't get it, you file an abatement application. You go through the abatement process. So Peace Ridge did submit an application the first year, but it didn't submit applications the next 2 years. So there was this big question of like, can we even procedurally be here right now? And maybe this is another interesting thing about Maine, where Maine has a court-created second avenue to an exemption, which is that you can just file a declaratory judgment requesting an exemption, whether or not you have filed an application or whether or not you have requested abatement. So you have two options. You can go the abatement route or you can go this declaratory judgment route. So we went the declaratory judgment route, and the court just affirmed that it was an option for us.
So in a different state, without that court-created avenue, you may have lost on procedural grounds.
I think so. I think we would have been shut out because they didn't timely appeal.
It's tough when you kind of have to fall back on equity, huh?
Yeah, but it was very nice for us that we had that option, because they came to us after all of these years had passed, and we took over the case and we started like filing all of the abatement applications on their behalf for the later years. But the deadlines were just long gone at that point. But it's a long line of cases at this point in Maine that just continually affirm that it's kind of a unique position that you can get an exemption through a declaratory judgment. So that was kind of the first question. And then the second question was, okay, so did Peace Ridge meet that use or occupy standard? So like it's April, the date at issue was April, the assessment date is April 1st, 2016. They bought the property in late 2015. If you know anything about Maine winter, which I imagine is very similar to Minnesota winter, our winter goes long past April 1st. So not a whole lot of work was done by April 1st, 2016. Like they had gotten a few quotes, and there were like some dogs living on the property. There were some pigs on the property. And they were fundraising to do more, but they couldn't move the animals on the property because the roads were posted. So they had to wait until the summer until the weight limits were lifted. So like the question is, it's like a huge 800-acre property. Like, is it enough to just like have a few dogs and have a few pigs over here and just have all of this work kind of going on in the process, in the background? And that's another issue that we won, because the standard that applied to the user occupied standard was, did the organization actually appropriate the property for its charitable purpose? And the court found that Peace Ridge bought the property with this definite intent to relocate and expand. So we won on that issue as well. And then the final issue, and I think like maybe the issue that has the biggest impact for other Maine organizations and organizations across the country, was, okay, so what about this conservation land? Like, is conservation a charitable use of property? And the courts around the country are really like all over the place on that issue. Some say yes, some say no. And we had, so the town was arguing that Peace Ridge had to basically like open up this conservation land for public use in order to qualify for the exemption. And that was based on this Holbrook Island Sanctuary case, which is a beautiful sanctuary, by the way. I was there like 2 weeks ago, and it's really lovely. But in that case, the sanctuary did not get the exemption because the court found that it was a game preserve, and because it didn't allow hunting consistent with Maine public policy, it didn't qualify for the charitable exemption. Like, you have to be in line with Maine public policy in order to qualify for the charitable exemption. So some years after that, we had another case on that same issue called Francis Small Heritage Trust. And in that case, the law court essentially held that, hey, Maine actually has a public policy supporting land conservation, and cited to like all these statutes where Maine has the public policy, and especially when the land conservation is coupled with some sort of public benefit. So we made the argument that, number one, conservation by itself is enough, but number two, Peace Ridge is not only conserving the land, it's also using the land for its sanctuary activities. Like, there were like dog walking trails around the woods, and we had one of the humane agents testify that the animals who are brought in such distress need those woods as a quiet buffer for their peaceful recovery and rehabilitation. And the court completely adopted that. They said that it was enough that we had like a few trails running through the woods. It was enough that this buffer land existed to create some quiet for the animals. So, and I think the interesting thing is that the court said, with respect to parcels where those activities weren't going on, that like, if those parcels were like in a conservation easement or a trust of some sort, that would probably be enough to get those parcels exempt. So I thought that was a pretty interesting decision, and the judge really got it right. So big win. Peace Ridge got its refund. The court actually ordered the town to pay our costs, which was a nice little bonus. It almost never happens. So yeah, thank you for letting me share that.
Absolutely. Thank you for sharing that. And thank you for, your time in this conversation. And we got to talk about a few things differently that we don't. So yeah, thank you for your perspective, and, also being a friend of the firm. And until next time, this is SALTovation.
Thank you.